The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon. Welcome to this remote oral argument session of the North Carolina Court of Appeals. I'm Richard Dietz. Joining me on the panel today are my colleagues Judge Hunter Murphy and Judge Jeff Carpenter. There's one case on the calendar this afternoon, and that's number 2695, State versus Reeser. We've confirmed that the parties are ready to proceed, so we'll hear from the appellant.
Thank you, Your Honors. Good afternoon. May it please the court. My name is Brennan Aberly on behalf of Mr. Reeser. I'm an attorney with Aberly & Wall based out of the Guilford County Bar, and if I may, I would like to reserve 5 minutes for rebuttal. So the case before us, this is as Your Honors probably well know, it's a DWI conviction, and there are two issues that I have put in my brief as assignments of error. The first is that the trial court erred in denying the motion to dismiss for insufficient evidence on the charge of driving while impaired. And the second issue is a little bit more novel, and I think the state and I probably at least agree on that. There weren't a lot of cases jurisdictionally here that were on point, but whether the trial court's decision to change the jury instructions without a hearing after the defendant had finished closing arguments and relied upon the agreed instructions, whether that caused irreparable prejudice and substantially deprived the defendant of his right to a fair trial. Turning first and briefly to the sufficiency issue, I think this is the one place where the state and I probably agree on the standard of review. It is de novo. The defense counsel did properly make a motion to dismiss at the close of states and all evidence. And I think we can even simplify this issue a little more further. There are three elements of driving while impaired, and only one of which was really the basis for the motion to dismiss and is really at issue here, which is operation of the vehicle. I'll touch on the facts briefly because it will make my prejudice argument on the second issue a little bit easier. But we have this DWI where essentially the facts are that a vehicle was found sitting at a gas pump in the Scotchman gas station, and the defendant, Mr. Reeser, is seated in the driver's seat when the only testifying officer, Officer Marshburn, arrives at the scene. And his testimony, he's very candid that he does not have a police report. He's very candid about what he cannot remember. He cannot remember the make and model of the car, or whether the windows were up, or whether it appeared that people were sleeping. But he uses this language that is very important. He says he approaches the car and the lights are on and the vehicle is running. But we get no further testimony about whether the engine itself was on, whether the keys were in the ignition, a lot of the testimony that we frequently see in DWI cases. After that, there's a whole DWI investigation on impairment that is outside the scope of this motion. But at the end of state's evidence, the trial counsel makes a motion to dismiss and specifically says, look, on operation, we just didn't have enough information. The state didn't present enough that a reasonable juror could return a verdict of guilt, even in the light most favorable to the state. The prosecutor, in arguing against that motion to dismiss, makes it very clear and again uses this language that is more specific, that the officer testified that the engine itself was running, which was not the language that Officer Marshburn himself used. The only other evidence we got after that was the defendant testifies, and he states that he's there with a friend. I think it's another friend who's a fellow United States Marine Corps member, and a third person. They were all going to a concert. There was this third person had driven a vehicle that is not registered to Mr. Reeser. It is not his car. They arrived at the Scotchman, went inside. When they came out, they spoke with another officer, an Officer Roman, who was not called to testify. And Mr. Reeser's testimony is essentially uncontroverted and uncontradicted. He states he spoke with the officer, this Officer Roman, who told him to sit in the car, and then they call for Officer Marshburn, who ultimately does the investigation. He testifies he never manipulated the keys, that he did not turn the vehicle on or off. And That is the crux of the evidence. And at the end of the trial, defense counsel renews their motion to dismiss based on that. And
So, counsel, in ordinary English usage, for example, if someone had arrived at someone else's home, was inside to pick them up, and said, "You need to hurry up. I left the car running," we would understand that in ordinary English usage to mean that the engine is on. That's a shorthand reference to the car being in operation. So isn't that alone just enough? And then it's for the jury to decide, is that enough to show that element beyond a reasonable doubt? In other words, for the judge, isn't it to say that a reasonable jury could infer that, and therefore this is substantial evidence?
well, Your Honor, I'll absolutely concede that a person could say the vehicle is running and mean that the engine is on. It is possible. And I'm not trying to make an untenable argument that just because the vehicle itself, there wasn't evidence that the engine was on, that you're good and you can get away with every DWI charge. I primarily do trial level work, and I've pled plenty of people guilty when it's fairly obvious that the only way that this person could have been here was that they must have driven the car, whether that's to the side of the road where their car is found or in the ditch where their car is wrecked. Why I think it's interesting in this case, and I thought it was worthy of bringing to your attention, is because nobody else uses that switched language later in the trial. Everyone always goes to careful lengths to say engine is running, engine is running. But the only testimony that's provided is vehicle. And certainly the vehicle could be on in that the air conditioning is running, the lights are on, the radio is running. But why I think that this issue is important is because there's another element of operation that we don't often talk about, and it's whether or not you can actually be operating a vehicle if you're told simply to sit in it. And that evidence was uncontradicted, that the defendant said, look, this officer who he was very nice with and complied with told him to go sit in the car. And it could certainly be conceived of several situations where you are asked to sit in an area and you may be in a place that has you sitting in the seat where there are controls in front of you, but you're not necessarily operating a vehicle if you're told to sit there and you haven't manipulated any keys. And in fact, the prosecutor concedes in closing argument that it really didn't. The prosecutor concedes in closing argument that it really doesn't matter if you believe that he drove to the gas station. The issue is simply whether he was sitting in the car with the engine running. Because that language wasn't used specifically, and the officer admits that his memory was fuzzy from that date, and the fact that the prosecutor goes to great lengths in the motion to dismiss, opposing the motion, to say, look, the officer did testify that the engine was running, but that wasn't the language that the officer used. I felt that that was an issue at least worth exploration by the court. If the court has any other questions about that issue, I'm happy to answer them. I'd like to turn to what I think is a more novel issue here. Yes.
Real quick, just turning to that issue of being told to sit in the car, that did stick out to me as I was going through the facts of this case. But wouldn't that go to potentially negate the willfulness element and not the operational element? And that wasn't made a specific ground in the briefs, right? There was no nothing in the briefs challenging the willfulness element on the motion to dismiss, correct?
That's correct, Your Honor. And I had thought about that. I'd thought about possible other, defenses, whether the trial counsel could have raised entrapment or something, but that is beyond the scope of my brief. My issue specifically is, if you were told to sit in the car, are you then operating it? And even though, and I agree with part of the state's brief that, we're not here to substitute judgment of the trial court or the jury with respect to facts, and we shouldn't consider contradictions in testimony. But I think it's fair to say that, interestingly enough, nobody ever really contradicted each other in any of the testimony that was presented, whether it was Officer Marshburn or Mr. Reeser. Their two sets of testimonies do not contradict at all. So with respect to this second issue,
before you move away from that, Mr. Avery, let me ask just a couple questions on that. First off, you're right, the entrapment defense, if it is, as the testimony was given at trial, certainly may have been a viable option for the trial lawyer, but the term operation or operating is defined in 20-4. And as it would apply in this case, would mean in physical control of the vehicle. Do you want to, you didn't dig into that really deep in your brief. Do you want to explore that any further on oral argument, or just
Well,
from the definition and statute?
well, and I agree. I've read the definition statute. I guess it comes down to more of kind of logic games, I guess, that I'm presenting here. If you and your child say are walking along an airplane and a pilot says, "Hey, do you want to sit in the seat?" and you set your child in the seat, they are now sitting there, but they're not operating the plane. They're not in control of the plane. And so I actually think, even though entrapment's a good issue and probably should have been raised, and willfulness is a good issue and should have been raised, I think that there's a fair argument that operation certainly implies something a little more active than sitting there. And I do think that is potentially an area where a jury could have found somebody not guilty, deciding that they weren't really operating the motor vehicle if they were just told to sit in the seat. So I guess that's as far as I can dive into that issue.
Okay, thank you.
Thank you. So the second issue is very fascinating, because I will concede the only thing that the honorable trial court did beyond changing the instructions was change these instructions to make them more correct. No one is disputing that. When at the point at which we got to the jury conference, the charge conference, there was a request about what kind of jury instructions does everybody want. They had thrown out the pattern jury instructions for DWI, and then those instructions were printed. They were passed out to defense counsel and to prosecutors. They had the chance to look over them. It's clear in the record that they did look over them. They each made objections to certain things. I think defense counsel specifically noted that Mr. Reeser's name was spelled incorrectly. There was a little bit of a debate about whether the definition of operation should be in there. But those jury instructions were printed out. They were looked at. They were agreed to. There was a 10-minute recess before closing arguments happened. And when that recess was over, there was one more chance to raise any objection. And no one objected to a jury instruction for driving while impaired that listed the elements as street or highway instead of street, highway, or public vehicular area. I'll concede that the jury instruction should have been written to include public vehicular area, because that's a more correct statement of the law. The problem is,
real quick, just so I'm clear on the record, I'm looking at record page 19 also. The street or highway isn't actually part of the charging document, right? The charging document only, if I'm interpreting this correctly, only included the public vehicular area. So not only is it more correct in law, it's basically required for it to meet the accusations in the charging document, correct?
Absolutely, yes. I will concede all of that. The issue, though, is the function of this charge conference is for the court to help define what are the important legal issues. Certainly, trial courts don't hand the indictments to the jury to decide whether people are guilty or not. They hand these jury instructions over, the jury instructions themselves are read. And so we've got this situation where a defense attorney detrimentally relied on the language street or highway. And it's clear in his closing argument, in trial counsel's closing argument, that he says over and over again, look, you're not going to hear any evidence that he was on a street or a highway. In fact, he says out loud, to the detriment of his client, had the jury instructions been the other way, there's evidence he was in a gas station, but there is no evidence he was on a street or a highway. And after that, the prosecutor, realizing that this had been taken out or mistakenly not in there, then argues, look, defense counsel kept saying street or highway, but that's not the law. And when the prosecutor finished, the trial court read the jury instructions, and as though the court knew that this was going to be an issue, the moment the jury left the room, The trial court said, obviously, I changed the jury instructions. Would you like to be heard? And that's the point at which defense counsel, whether or not he uses magic language about constitutional right to a fair trial, he makes it very clear that he knows what he agreed to and that he tailored his argument based on the way that the court had told him the argument was going to be. And he made a big deal out of street or highway. And the functional result, inadvertent as it was, the functional result is it sort of impugned the defense argument and made it appear as though defense counsel didn't really know what the law was. And it deprived the defense counsel of being able to tailor their closing argument to clarify the issues at hand. So I certainly.
Counsel, I think
Yeah.
we're going to hear from your friend for the state that, I mean, you referred to it as magic words, but I think what your friend for the state is going to say is that as you acknowledge, this is a somewhat novel question for our appellate courts. And so that therefore a novel question for the trial court in confronting what to do here. And that if there is a constitutional defect in the trial court's handling of this, that trial counsel had an obligation to identify the applicable constitutional right and tell the trial court so the court could weigh whether it needed to craft some remedy to address the constitutional violation. And that what the court may have been just deciding is, do I just need to allow closing argument to happen over again and then conclude it in my discretion, or whatever the applicable legal standard, I'm not going to do that. And we're just reviewing whether that was traditional harmless error. So what's your response to that? I think we're going to hear that argument from the state.
Thank you. So my response to that would be that as I understand the preservation rules in the rules of appellate procedure, that there is an obligation on trial counsel to state the specific grounds if they're not apparent from context. And I would argue that it would appear in the context, in the entire colloquy that happens back and forth, that defense counsel makes it very clear that the changing the jury instructions led more credibility to the prosecutor's argument, and that he had approved of it written in a certain way, and actually asked the court to make a finding on the record that he had based his argument on what he was led to believe the law was going to be. Again, he doesn't use the phrase, my client's constitutional right to a fair trial was denied, but I would suggest and hope that the court would see that from the context, from the trial counsel's insistence that we be on the record that his argument was tailored to the original language, that the only objection he could be making was some fundamental fairness related one. Let me say this quickly though, because I know I have read all of the case law from the state's brief on this, and I can't help but feel that there's a little bit of a disconnect. I completely agree that the standard of review, when the jury instructions are not what the defense has argued for and asked for, is abuse of discretion. But I think that that is entirely separate from the issue that we have here, because we don't have an issue where there was a charge conference, the defense had the opportunity to be heard, the prosecutor had the opportunity to be heard, and then they both said, I want this, and a trial court heard the arguments and then made a decision about what it would be. If that were the case, I would say this is abuse of discretion. But this is a case that brings up a new area of law for us, and I don't think abuse of discretion is the appropriate standard of review, and I don't think any of the cases that are cited are really in North Carolina are on point to this. I will concede I've had to go out. I found this People v. Clark decision and 4 other cases. I don't know if the court has read that decision in full. It is a Michigan Supreme Court case. The only difference is we're dealing with involuntary manslaughter versus driving while impaired. And in that case, there was a charge conference. There was a debate about whether gross negligence should be defined to the jury as reasonably should have known that serious injury could occur or reasonably should have known that death could occur. And the court decided that it would be this higher standard originally. The prosecutor argued, defense objected again and got the court to change their mind that it would be this lower standard. And then defense counsel argued, and then when defense counsel asked to make sure this modification was still going to stand, There was an additional hearing, and then the court read the original instructions. And the language in People v. Clark is very clear. In fact, it's so clear, it almost makes me believe that it may not matter what the prejudice standard is when we're dealing with an issue where the jury instructions were changed at the 11th hour, because they cite our cases as well as federal authority indicate that when trial court errs in misleading or misinforming counsel regarding the ultimate instructions that will be given, a new trial is required. They actually go into the remedies, and that re-instruction is probably not even proper in a case like that. They state that a change in the jury instructions at the 11th hour, which has occurred here, should only be made with extreme caution. In this case, defense counsel was inadvertently, not purposefully, inadvertently misled by the court and argued the wrong theory to the jury, and consequently his ability to defend his client was impaired. With my last couple of minutes, I'll say this. So assuming that we now have to decide what prejudice occurred, if any, I think it's difficult to conceive of a way that this didn't massively prejudice him and that the outcome likely would have been different, because the prosecutor admits in closing argument, look, it doesn't matter if you believe that Mr. Reeser was the one who drove to the gas station. That doesn't matter. That's not controlling. What matters is if you believe he was sitting behind the wheel and the engine was running. And because of that, it gave the jury a way to find Mr. Reeser guilty based on the public vehicular area only. And that was off the table when defense counsel was making their argument. In fact, the jury came back with a re-instruction request on reasonable doubt, showing that they were certainly grappling with this issue. And it made the state's case significantly easier to include public vehicular area. Again, it does not matter that what the court did was make it more correctly. And they addressed that in People v. Clark with this language. Under no circumstances do we conclude, advocate, or imply that a trial judge has a duty to instruct the jury incorrectly, nor do we say that a judge erred by refusing to give erroneous instruction. The prejudice to the defendant in this case was incurred by the virtue of defense counsel's argument in reliance on one instruction and the judge's subsequent decision to instruct the jury on a different one. This misled defense counsel in formulating his closing argument. So I'll admit that there's no direct case here, but I think other jurisdictions that have dealt with this have found it's an unfortunate situation. Nobody's advocating anyone did anything malicious, but at the end of the day, Mr. Reeser has a right to closing argument, to a fair trial, to effective assistance of counsel, which is not what I raise here, but these issues are related. And you are deprived of that right to a fair trial when the purpose of jury instruction is to clarify the issues and defense counsel becomes misled.
Sure. With the concession that the state may have evidence of the gas station, the defense counsel didn't admit all of the elements, correct, in the closing. So it's not a situation where we have basically this adding up to a Harbison admonishment issue. There wasn't a concession on the operation at any point, correct?
That's correct. I don't believe that there was any concession on operation, and I didn't raise a Harbison issue there. I didn't see one, but I would tend to agree with the court, at least with respect to that. Yes.
Mr. Aberle, in regards to the standard of proof, or the standard of review, that's kind of a big deal for us. We have to know what prism or what lens we're looking at your case through. 15A-1231 in the Criminal Procedure Act says that the standard is the failure of a judge to comply with basically the charge conference does not constitute grounds for appeal unless his failure, not corrected prior to the end of the trial, materially prejudiced the case of the defendant. So what's the standard of review that you would have us apply in light of the language from the statute? And if it's material prejudice, what does that mean?
Your Honor, that's a great question. So I believe that that statute gets on point to when there are failures that occurred with the charge conference itself. But again, I don't think there was an error with the charge conference. I think the court complied with the statute. I think the problem is what happened after that when the court then changed the instructions. And that's why I believe it's a constitutional error and one that requires a de novo standard. Assuming arguendo that the issue here is that the court didn't comply with that and that there is material prejudice, I would tend to argue then that the material prejudice is prejudice that is likely and has a good likelihood of changing the outcome of the case. And I would argue that when the case became that much easier for the prosecutor by adding this extra language, and the prosecutor admitted that you don't even have to believe he drove to the gas station in the first place, you can find him entirely guilty within public vehicular area and public vehicular area alone. I think the prejudice is clear and material. But I would argue that
Counsel,
it is. Yes.
Let me follow up on that. So, because, you know, when you talk about the Michigan case, I think you were almost making an argument that we should just find structural error. And I think we certainly can't do that here because it's just not within the categories that our Supreme Court has indicated can be structural error. So there must be some prejudice prong, and it's either the constitutional one, harmless beyond a reasonable doubt, or it's our standard harmless analysis, whether there's a reasonable possibility that the result would have been different. But I think in this context, the parties can't stipulate to what the law is. So the error by the court cannot have been the instruction it gave because its instruction was correct. So the error was misinforming the parties about that and causing, during closing argument, counsel for your client to provide an argument that would have been different had counsel understood what the instruction was going to be. But I think your friend for the state is going to argue that is harmless because there's really no evidence in the case on which counsel could have relied to make an argument that this isn't a public vehicular area. So even knowing that that was going to be added into the instruction, it could not have changed the arguments that counsel could have made in a way that would have influenced the outcome of the case. So what's your response to that?
My response to that would be, and based again on my reading the Clark case, that the issue is him tailoring his arguments specifically on a way that the jury instructions were written. That's a constitutional error, and the prejudice, whether the court wants to analyze this under beyond a reasonable doubt or harmless error, that the prejudice is clear in that it would certainly, if that language was not in and the judge did not read it and the jury was only to decide whether or not he had been on a street or a highway at some other point, if the judge was bound by that language and had chosen not to go back on it after a hearing, I think the prejudice is clear that the defendant was far more likely to be convicted of DWI with the new language in there, particularly given the fact that no one had seen the vehicle in operation and that the state even conceded that no one knew who drove the vehicle to the parking lot in the first place. I'm not disputing that you could be found guilty being in a parking lot and that there was evidence that he was in a parking lot. But I think that the issue is when you relied on the language that did not include it and he then tailored his arguments to it. That was the point. By being misled, that was the point at which the constitutional error occurred and he was deprived of his right to a fair trial.
All right, thank you. We'll reserve your remaining time and we'll give you slightly more time because our questions ate into your rebuttal there a bit. We'll hear from the state.
My name is Ryan. May it please the court. My name is Ryan Zeller. I'm with the North Carolina Department of Justice, and I represent the state in this matter. Your Honor, there are two issues before the court today. The first issue is whether the state presented sufficient evidence to support a prima facie case that defendant was operating a motor vehicle. The second issue is whether the trial court properly corrected an omission of public vehicular area in the jury instructions in order to properly instruct the jury the statutorily defined elements of driving while impaired. Today I would like to discuss four main points with the court. First, defendant's motion to dismiss was properly denied by the trial court because the state provided substantial evidence the defendant was operating a motor vehicle. Second, defendant's constitutional argument must be waived because he failed to specifically object at the trial level based on constitutional grounds. Third, the trial court properly corrected the jury instructions to include public vehicular area, and in so doing fulfilled his, quote, obligation and duty to apply the applicable law to the evidence presented at the trial. And fourth, defendant was not materially prejudiced by the trial court's correction of the jury instructions to include public vehicular area because there was overwhelming evidence of public vehicular area in this case. Public vehicular area simply was not central to defendant's defense in the case. And third, defendant's counsel in a way invited the error by applying the improper law of DWI, not only during the jury charge conference, but also during his closing argument. So with regard to the first issue, the trial court properly denied defendant's motion to dismiss because the state provided substantial evidence that defendant was operating a motor vehicle. With regard to a motion to dismiss, the state will successfully survive the motion if there's substantial evidence that defendant committed each essential element of the crime. Substantial evidence is defined as relevant evidence that a reasonable mind might accept as adequate to support a conclusion. This evidence must be viewed in the light most favorable to the state, giving the state the benefit of all reasonable inferences. Contradictions and discrepancies do not warrant dismissal of the case, but are for the jury to resolve. And when ruling on a motion to dismiss, the trial court should be concerned about only whether the evidence is sufficient for the jury consideration and not about the weight of the evidence. And finally, defendant's evidence should be disregarded unless it is favorable to the state or does not conflict with the state's evidence. So moving on to the essential elements of driving while impaired in view of that standard. Those elements are the defendant was driving or operating a vehicle upon any highway, any street, or any public vehicular area within the state while under the influence of an impairing substance. As defense counsel has stated earlier that they are only objecting to the drive or operation portion of this. For a defendant to be considered to drive or operate a vehicle, the defendant is considered to drive or operate a vehicle when he is in actual physical control of the vehicle, which is either in motion or has the engine running. And that's 20-4.01, 7, and 25. This court in State versus Mabe, State versus Hoke, State versus Fields have all concluded that an individual who is asleep behind the wheel of a parked vehicle within a public vehicular area with the engine running is considered to have actual physical control of the car, thus within the meaning of the statute.
Counsel, the argument that your friend for the defendant is making is that the evidence was a single piece of testimony from the officer that the vehicle was running. And the argument is that's just not enough to show that the engine was running. So why don't you address what is the state's position on that argument? Sure,
yeah. Thank you, Your Honor. Page 38 of the transcript, I think it's important to read exactly what Sergeant Marshburn's testimony was. He testifies that I noticed that the vehicle was running and the headlights were on. That connector "and" I think is important here. Not only is he saying that the vehicle was running, as Judge Dietz, you previously mentioned, in common ordinary English usage, that would suggest that the engine was running, not just the headlights were on. But to eliminate any question about whether the engine he was referring to the engine, he also added that the headlights were on. So there are two distinct pieces of that one sentence of testimony that I think eliminate defendant's argument that that we're kind of parsing between the engine or vehicle being on.
Well, just to give you an example, though, and I'm going outside the record here, but if I sit in my car and turn the key just one notch, the air conditioner comes on, the headlights can come on, the radio can come on, the engine doesn't start.
Mhm.
So, you know, the argument I understand your friend for the defendant was making is saying the vehicle is running doesn't show, it isn't enough to say that the engine was running, and there needs to be substantial evidence that the engine's running. So, you know, how do we know that the engine is running based on the evidence that's presented here?
Well, I think it just goes back to this was a testimony, a trial testimony in which Officer Marshburn was presenting his evidence, and I'll grant you he didn't use the magic words engine, but again, we're talking about a motion to dismiss here. We're not talking about a potentially faulty indictment, which would require those magic words to be uttered verbatim. Here, this is just a testimony. I would argue, again, the connector and suggests that something more than just the one click occurred here, that the engine actually was running and not just the vehicle. And in addition, the headlights were on. But going back to State versus Mabe, that court stated that to be within the purview of the statute, all the state needed to show was defendant was seated behind the steering wheel of a car, which had its engine running. So applying to this particular case here, as we previously noted, Sergeant Marshburn testified that the vehicle was running, the headlights were on, defendant was seated in the driver's seat, looked like he was sleeping, and that was all within a public vehicular area, which is the Scotchman gas station at the gas pump. So when viewing the evidence in light most favorable to the state, giving the state the benefit of all reasonable inferences, the trial court properly denied defendant's motion to dismiss. Moving on to the second issue, the trial court properly corrected a misstatement of the law and the jury instructions to correspond to the applicable law in light of the facts of the case. But before we get into the meat of that argument, we must discuss the constitutional preservation argument, in which defendant failed to preserve his constitutional argument, on which his entire second argument regarding jury instruction is based. In State v. Gainey, the Supreme Court of North Carolina noted that when a defendant objects but does so on grounds other than constitutional issues, those constitutional issues will not be considered for the first time on appeal. Likewise, the Supreme Court of North Carolina in State versus Call noted that arguments of constitutional error that are not raised at trial are deemed waived on appeal.
So, counsel, your friend for the defendant addressed this. His argument is, I argued to the trial court, or the counsel argued to the trial court, that this is depriving the right to a fair trial. Right to a fair trial is a component of due process. So, trial court was aware that they were making a constitutional argument. So, why don't you address the argument you heard from your friend for the defendant? Why isn't that enough to preserve the constitutional claim?
Because, Your Honor, the standard for objecting on a constitutional issue should not be left to interpretation. It should be crystal clear on its face. To me, when I read the objection, let me just read exactly what counsel said on pages 125 and 126. Judge, I was given the verdict. I mean, the sheet that I have, street or highway, no public vehicular area. So it allowed me to argue street or highway. Just made a little bit of hay, I think. And that's one I approved, the version I approved. And the court added public vehicular area, which led more credibility, I think, to the state's argument. And Judge, I know what the law is, and I know what I approved. I'm going to object to the way they were instructed. Really, what I'd like to see, what they come back with, and then would the court make a finding that I had already argued street or highway to the jury before? To me, I don't think that's as clear as defendant would like it to be, that this is a constitutional issue. That certainly could be arguing that there's a violation of the statutes, North Carolina general statutes regarding the jury charge, and that he felt that he was prejudiced on that, which is how I kind of read that transaction. So again, this is a constitutional question.
Well, Mr. Zeller, let me ask this: if he's saying that he knows what the law says, then isn't he abandoning statutory arguments, and then by implication, his argument and desire to preserve the record falls under the Constitution? I think we'd be taking a real strict look at our preservation rules if we said you've got to say exactly which constitutional provision you're talking about and be completely clear on this. We don't require, somebody making a Fifth or Sixth Amendment argument to also talk about how it has to be part of structured liberty and that therefore it applies to the states. We don't have all these different steps that a litigant has to hit in their argument for preservation purposes. So, why should we take a strict magic words approach here, which seems like what the state's asking us to do, given that the content of the argument does match up with these due process and fair trial concerns?
Your Honor, and your point is well taken. To me, I think that there just needs to be a little bit more reference to a constitutional issue, and I think a lot can be said of the court's reaction to the objection. Had the court felt that this was a constitutional issue, I would have thought that the court might have attempted to have a curative instruction at the very least, if not allow re-argument of the closings. It did not appear that the court in the middle of the objection felt that this had anything to do with constitutional grounds. And that's to me, I think that the court would have acted differently if it was clear that this was constitutional on its face. But
So, Mr. Zeller, a couple quick questions for you. First off, before we get done, I want you to address the standard of review that you believe we need to apply in light of the language in the statute, 15A-1231. But first, the judge instructed this jury, the defense counsel in this case was presented with a draft copy of jury instructions that had the headings on it. Both copies appear in the record. On the record, page 11, the instructions that were presented indicate that the second element is the defendant was driving that vehicle upon a highway or street within the state. Move down to the mandate portion of that instruction. It also says, if you find from the evidence a reasonable doubt that on or about the alleged date the defendant drove a vehicle on a highway or street in the state. No public vehicle area there. The correction, as I understand it, was made post-closing argument after the defense counsel had these instructions that they agreed on in hand to aid and assist in his argument to the jury. And you used the term statutory elements earlier when you were talking about the judge redefining or correcting to comply with the statutory elements. So the statutory elements that were presented to counsel prior to closing argument were street or highway. The statutory elements that were presented to the jury without hearing from counsel for the state or defense were street, highway, or public vehicular area. So an additional element that was an opportunity for the state to prove was added without hearing. And I think your colleague on the other side his position is that we crafted our argument around what the judge told us the instructions were going to be and argued that to the jury. And after we crafted that argument and argued to the jury, the judge changed the elements that she presented to the jury without hearing from us, thereby negating the effect of the entire closing argument of defense counsel. I think that's the position that they're taking. Also, in the closing jury instructions, the judge informed the jury this is the page 17 in the record. The law requires the presiding judge to be impartial. You should not infer from anything I have done or said the evidence needs to be believed or disbelieved that a fact has been proved or what your findings ought to be. It is your duty to find the facts and to render a verdict reflecting the truth. That's not what I was looking for. Anyway, the judge instructs the jury that you are to apply the law as I give it to you, not as you think it is or as you think it ought to be, which basically has taken from the defense counsel's perspective, has taken that a step further, given the judge, he's argued this based on what the judge has given him in the charge conference. And then the judge says, you can't believe what the lawyers tell you, you have to take the law as I give it to you. And then the judge gives different law than what was agreed upon in the charge conference. That's the impetus of the constitutional argument that's being made here. So I know that was long and roaming, but in light of that, I'd like to hear your thoughts in regards to the constitutional things, and also in regards to the standard of proof in light of the material prejudice language in the statute, what that even means, because I don't think there's any case law on that.
Thank you, Your Honor, and I'll do my best to address each of your questions. With regard to the standard of review, you're right. I mean, my colleague is correct. I think both of us were unable to pinpoint a case that has this particular set of facts to a T in the case law. That is, the trial judge provided a jury instruction that was not accurate based on the facts of the case, and ended up after the fact correcting that error to have it applied to the facts of the case. But there are certainly cases that require the trial judge to says that the trial judge has a duty to explain without special request, therefore, each essential element of the offense, and to apply the law with respect to each element of the evidence bearing thereon. So the trial court does have a duty to correct a misstatement of the law, and in this case, that's what this was, because this was never a case about street or highway. There was never a testimony that defendant went from this street to this street to this street. The testimony starts with Sergeant Marshburn coming to a Scotchman gas station, which by definition is a public vehicular area.
So, counsel, just so we're clear here, though, I think your friend for the defendant was very clear about what the prejudice, what the material prejudice would be here, and it's not, and he concedes that that the trial court gave a proper instruction and was required to give that correct statement of the law. The argument is, having been told that the court would give a different instruction, trial counsel crafted a closing argument that spent time asserting arguments based on the incorrect statement of the law, focusing on the street or highway, and that by doing that, not only did counsel not focus on other parts of the argument during that part of closing, but also may have caused the jury to say, well, this lawyer for this defendant is a liar because, or misled us because what about this public vehicular area? And this gas station certainly is that. And so why did this lawyer tell us that we should only be thinking about street or highway? And that was the prejudice that your friends for the defendant's arguing. So why don't you tell us why that's not material prejudice and why it wouldn't meet a standard for a reversible error?
Well, respectfully, Your Honor, you mentioned that the defense counsel basically forego some of the issues of the case, and I don't think that's what happened here. In fact, the defense counsel in his closing argument labeled the big issue, quote unquote, big issue that defendant's attorney, that the big issue of the case was whether defendant was the driver of the vehicle and whether he was instructed to sit in the front seat by Sergeant Roman. He went on to mention a couple of other little, quote unquote, little issues, his words, that, and one of those was the public vehicular area. And the extent of that argument was three short sentences. No evidence it was ever on the highway. No evidence it was on the street. There's evidence it was at a gas station. And take that and combine it with the fact that the defense counsel was aware of the charging document that included public vehicular area. Defendant's counsel was aware during the charge conference that the trial court intended to use the pattern jury instructions for driving while impaired, which includes in its definition public vehicular area. And the trial defense counsel, I'll grant you that the prosecutor did not object to the jury instructions, but so too did not the defense attorney did not bring light to this issue before his closing argument. And I think that's problematic because, again, in his own words, he says, "I know what the law is, but I know what I agreed to." So defense counsel, to me, it appears that the defense counsel understood what the law should have been based on the charging document, based on all the evidence that was presented at the trial, saw that the public vehicular area was not included in the jury instructions originally, and attempted to argue the incorrect law that he knew was incorrect based on the evidence of the case. And then turned around and objected once the correct instructions were corrected. That, to me, that's inviting the error by defense counsel, and I think it would be bad policy for the state to allow that type of behavior to result in determine that there was any material prejudice as a result. And again, the public vehicular area was never a prominent issue of this case. It was always the drive and operation prong of the statute. So, the question is, was he prejudiced? I don't think that we're in a position to determine that. But I think we're certainly in a position to determine that he was not materially prejudiced. And I think that's what the key here is, that, listen, the trial court admitted that there was a mistake. He corrected that mistake to comport with the facts of the case, the undisputed facts of the case, and he went from there. And one more thing, I think it's important to note that the defense counsel, when informed that the jury instructions were going to be corrected, he didn't request a curative instruction from the court. He just simply objected. And I think that's important too, that to kind of show that there might have been a little element, again, of invited error that occurred here.
Mr. Zeller, let me ask you a question. Let's assume we hold that the constitutional argument was preserved and that there was prejudice to at least some degree as to the effect on the credibility of counsel to the jury. What about People versus Clark for the Michigan Supreme Court? Basically, why should that not be persuasive, or what would be different under North Carolina law?
Yeah, thank you, Your Honor, for pointing out People versus Clark. Again, I think that there are several things with that, and I think that the dissent, one of the dissents, points out very persuasively that their case law, in his view, a judge is under no duty to give an erroneous instruction, regardless of what he tells defense counsel. And I think that's kind of where we are here. We're, again, I think the dissent also noted that ultimately what we would be doing here is saying that the trial court erred by not committing error. So that's kind of the conundrum that we have here. The trial court tried to do the right thing. I'd be hard pressed to believe that defense counsel in this case would have been surprised in the least if public vehicular area was included in the original instructions.
That's probably true, Mr. Zeller, but the argument is that had that been included, his argument would have been different. His closing argument would have been different. And to be clear, if the trial judge had instructed the jury as she did, but only included street or highway, that would not have been an erroneous instruction. That's proper under the law. It's also including PVA was not an erroneous instruction. It was proper under the law. So it's not whether we're dealing with error in instruction. Both instructions would have been proper. It's just the question of crafting an argument based on the leaving out of one of the criteria that the state could convict the defendant under.
And thank you, Your Honor. And again, I think in the Clark case, that the instruction that was changed, one, it was a request by the defense counsel, kind of an affirmative request by the defense counsel to make that change. And then the trial court realized that was incorrect and changed it after the fact. Here, this was just trial counsel trial judge just failed to include public vehicular area when the evidence and the charging document and everything was clear that should have been included. The second thing is the court in Clark concluded that the change in the jury instructions was, quote, substantial and eviscerated the defense's argument. So had the jury instruction issue, for example, in this case, been with regard to the operation prong, which was almost the entire argument of defense counsel. That's what People versus Clark was. But here, there's just this issue that is of public vehicular area where everybody knew that there was public vehicular area at the gas station, defined by the law, and that I think that's important to note too. And so, for the reasons discussed today, the state respectfully requests the decision of the trial court be affirmed.
Thank you, counsel. Any rebuttal?
Mr. Abel, we can't hear you.
I apologize, Your Honors. Yes, very brief rebuttal, and only to address some of those new areas. Again, the People v. Clark case is so interesting because it addresses every single one of my colleagues' issues. In fact, in that case, the prosecutor actually agrees that there is an error when the judge changed the instructions, but the state in that case does not disagree that that's an error. But they argue, the prosecutor further argues that the defense attorney should not gain an advantage after deliberately injecting error into the proceedings and then refusing to correct the error by re-arguing when he had the opportunity to do so. The court says, look, we disagree with that. This error is not minor. When the defense counsel relies on an instruction, that is going to have a serious effect, especially when there's a big gap between the two standards. And here we have a large gap between street, highway, and public vehicular area, or street, highway alone. So I think it's constitutional. I think it's apparent from the context that he's raising a fair trial issue. I think the court anticipated that this would be litigated up here because we've read the colloquy up until the part where defense attorney objects, but after that, the court says on page 126 of the record, I'm going to note your objection, and I want to make sure the record's clear, and if it's not, I'm going to make it clear. Jury instructions that we went through and I gave a copy to counsel did not include public vehicular area. As Madam Villa was doing her argument, I noticed and corrected it and instructed the jury on public vehicular area. I will let the record, because everything's recorded, but Mr. Smith specifically argued to the jury the issue about it not being on the street or highway. I will note your objection for the record, and we will see. I think that there was an anticipation that we'd be here. I think people wanted to preserve the constitutional issue here. And I think that if we're looking at harmless beyond a reasonable doubt, we cannot say that this error was that, because at some point the defense attorney looks the jury in the face and says, we have evidence, we don't have evidence of a street or a highway, we've got evidence of a gas station. And I don't think it's a good idea to presume that had this instruction not be changed, the defense counsel would have fully admitted a full element of DWI to the jury. And the result was it looked like the defense attorney didn't know what the law was, and we'll never know what that credibility hit did to the defense's case and whether the defense counsel would have spent more time simply arguing operation. And that is all that I have. If the court doesn't have additional questions.
I'm sorry, I was muted. Thank you, counsel. We'll adjourn. Mr. Soar?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you. And you're free to drop off now anytime. This is sort of your virtual version of walking out of the courtroom. So thank you both for your arguments.
Thank you, Your Honor.